Today is Tuesday, August 14th, 2012. This is the Hyatt Regency Maui. I am here today to interview Judge Dorothy Nelson in a brief oral history to record some reflections on her career, her long career in the law. I am Gail Migdal title. I'm here on behalf of the Ninth Circuit Historical Society, and this interview will be preserved and stored with the society, and you will be given a copy for your own use when we're done. I know, Judge Nelson, you've been interviewed a multitude of times before. Every interview I've seen has been just on paper, so I'm really pleased that we can put this on videotape and get to have the rest of the world share the personality behind the words. So I'm really looking forward to interviewing you today. I'm going to go through a standard list of questions for the oral history because we're trying to make them, fairly standardized for all the judges. But so my first question is, of course, what made you decide to become a lawyer?
I started out in life loving to work with children, and since I had been a YMCA counselor where I met my husband in the 11th grade, I found that working with these children, most of them, well, all of them were underprivileged. They needed health care. Their family needed attention. I would go and they say, well, the law says this and the law says that. And I came home and said to my parents, I'm not going to be a social worker. I'm going to be a lawyer. I want to change things to make things better. And I think that lawyers would have more power to do this. So it was really about that time, although I was a general major at UCLA and didn't change to political science till my junior and senior year. Supposedly that was the best thing to do. I'm not sure I would do that again. And so that's really the inkling that I got. When I graduated from LA High, I was a speaker for Girls State of the Year, and a number of lawyers invited me down to their offices and said, you ought to go to law school. And there weren't that many women lawyers.
Well, that's what I was going to ask.
Yes.
I mean, it must have, did you have any, sense of uncertainty, or did it give you pause to think about becoming a lawyer? Probably in the late 1940s, you probably started in around 1950 if you graduated in 53?
Yes.
What thought did you give to that?
In my family, my mother was a career woman. She was an educator, a teacher. And it was never a question of, well, my high school counselor said, and dear, what are you going to do until you get married? I said, when I get married, I would like to go on and have a profession and raise a family as well. But in my family, it was just sort of expected. I had two sisters, and both of whom went on with their own careers.
Yeah, so you came from a whole family of powerful women.
Well, I used to think of my sisters as very, very powerful. Now, my mother was quite an example. And my father was a building contractor, but it was always just expected. We'll go to college, we'll go on, and we'll do something, as my parents used to say, as long as you're serving humanity in some way, you will be happy. So it wasn't a question of being a lawyer to make money. It wasn't a question of, it's a great profession kind of thing. If you think you can serve humanity in that way, then do it.
So how many women were there in your class at UCLA?
My law school class, 2. I was one of them.
Out of how many?
We were the second class at the UCLA Law School, so we're very small. We were only 72 of us. So
2 women.
My friend Ann Mobley and me, we were there. But oddly enough, and women lawyers today don't quite understand it, never felt discriminated against. And in fact, one of our law professors would say, well, he is now deceased. He had an unusual way, but he'd say, I'm never going to call on a woman except when I say it's Ladies' Day. Well, we loved it. Because we never were nervous in class until the night before Ladies' Day. We stayed up late, and we were so superb in class because we were extra prepared. But even with the rest of the law school, the rest of the faculty, the next class, I think there were 7 women and so forth. So it was a beginning.
That's great. That's great. So what prompted you to get a master's in law?
Oh, well, I'd always been interested in law reform, making the system better. Just before graduation, we had Dean Roscoe Pound, formerly of the law school, as our Dean Emeritus at UCLA. He wasn't. And I had him for 7 courses. And one day he called me in and said, University of Southern California is looking for a research assistant for one of the faculty to do a 3-year study of the court system and how it might be improved in LA County with a comparative study with San Francisco and San Diego. Would you be interested? Well, at the same time, I had been an extern for Judge Mathis, one of the first.
Maximum
Yes,
Mathis.
you knew him well because he was very sweet outside the courtroom, but boy, it was the sentences that he imposed were really extreme. And I had met Paul Fussell of Melvin and Myers through him. So I was invited down to Melvin and Myers, and they offered me a job at $350 a month. This program at USC, $250 a month, plus my master's. I had to take 20 units, and I assisted in writing this book. And we came up with 33 proposals for improving the system, the first court executive and so forth. They were passed by the legislature. And that is how I ended up at the USC Law School, because one of my professors in a course called Judicial Administration, Improving the Administration of Justice, was called to Europe. And because I'd been working on this book, the dean called me in and said, how would you like to take over this class for the rest of the semester? Well, the class had really been abysmal. It was taught by a vice president, now deceased, of the university, came in late, anecdotal. Well, I had interviewed 2,000 jurors. I'd interviewed every judge in LA County. And I said, we're going to see how the courts really work. And so we had class 2 hours a week and then a field trip. When I started in the drunk tank, we interviewed the judges, we interviewed some of the clients, took them up to the state Supreme Court, and then I went to the federal court and took them through that. Well, while I was working on that book with this professor, something I had never planned to do, Justice Tom Clark of the United States Supreme Court came to town, and he had a committee for the improvement, the administration of justice. And the dean called me in and said, Justice Clark needs a reporter. Are you interested? I said, am I interested? And that was a lovely thing, because at the end of the course that I taught, I called Mr. Justice Clark and said, is there any chance you would meet with my seminar? There were only 20 of us in judicial administration at USC. Well, honey, anything you want, I will do. I ran down to the dean and said, Justice Clark's going to come and meet with my class on such and such a date. He said, oh, no, he's not. He's going to meet with the whole school. But after teaching that course, the students went into the dean and said, hire her, hire her. And I always joke and said, Dean Kingsley said, but she's a woman. But he didn't really say that. He was very supportive, and that's how I got to be the first woman faculty member at the USC Law School.
Great.
So it was right time, right place. I went down to Melvin and Myers in 6th and Spring. You're on this floor for 6 months, then you move to the next floor for 6 months, then you move to the next floor. And then I went in to talk to this Professor Holbrook, and I was interested in children and writing chapters on the juvenile court. In law school, I sort of fought the system. The adversary system, to me, did not always produce what I thought was fair and just. In the words of Chief Justice Burger, too costly, too painful, too ineffective for a civilized society. And then right after law school, I became a member of the Baha'i Faith, which is a world religion. I was raised as an Episcopalian, but in our law school class, we were all invited to join a legal fraternity, Phi Delta Phi. There were 2 women, 1 black. 6 weeks later, they wrote back and said, sorry, no women, no blacks. The president of the class someone I thought was a former playboy in undergraduate school called us together and said, let's all resign. This is 1950, even before Brown, and form the UCLA Law Society. And everybody is welcome. So I walked up to Donald and said, Donald, that was really a nice thing to do, but whatever led you to do it? And he said, I've been going to Baha'i meetings in Westwood Village, and they believe in equality of women and men. They believe in the abolition of prejudice. Would you like to come to a meeting? And I said, well, no, thank you, Donald. I'm very active in my own church. 2 weeks later, he and his wife had us to a steak dinner. Now, mind you, we were starving law students, living on hot dogs and macaroni and cheese, and we were going to play bridge. He starts to pass out the cards, and I say, there's a Baha'i meeting 2 blocks away. Would you like to go? My husband looks at me. We're obviously free for the evening. We've had a steak dinner. So I said, that will be very interesting. And my husband, as we walked the door, said, let's stay close to the door, just in case it's weird. Well, that was our first Baha'i meeting. And oddly enough, Donald became, not so odd, a Baha'i in our second year of law school. And we all watched him like a hawk. And he wasn't number one in the class, but when he talked about issues of equality, discrimination, and so forth, you could hear a pin drop in the room. Out of my class of 72, in the next 10 years, 17 of us became Baha'is, and we're all over the world. And so Baha'is resolve things through what we call consultation, which is a high form of mediation. Mm-hmm. So I added mediation to my course on law reform. At one faculty meeting at the end of the table, I heard a faculty member, what's Dorothy teaching? Mediation. That has nothing to do with the law. The answer was, oh, she's just trying to make everybody happy. Well, it gives me great joy to say it's one of the hottest topics in the justice system today.
Must give you a lot of satisfaction.
And that led to my interest in what some call alternative dispute resolution. Janet Reno called it appropriate dispute resolution. Led to my committee on this court. As a new judge, when I came on the court, I said to Judge Browning, why don't we have a mediator in the Court of Appeals? He said, why would anybody mediate when they won below? I said, well, they might just lose with us, besides which we may get a better decision. So he set aside one clerkship position, and he said, Dorothy, if it doesn't work, it's just for 1 year. We went from 1 to 3 to 5 to 7 to 10, and Congress pays for them now. And this incredible group of mediators on our Court of Appeals took 1,000 cases last year. Our caseload was 5,000 when I came on the court. I think we have 15,000 backlog, but they took 1,000 cases. It was close to 80% were resolved peacefully.
And is that, how did they pick the 1,000 cases?
How do they pick them?
Mm-hmm.
They do screen them. Judges refer some cases that they get. They prefer to screen them and get them before they've come to oral argument. Sometimes we'll get briefs, and we'll say this case should really go to mediation. And it's cases of employment discrimination, or sex discrimination, or race discrimination. Take employment discrimination. The person wants the job back, wants equal pay, wants the policy of the company to change, and yet they've sued for, say, $8-9 million. And when the mediator says, what do you really want? The employer is only too happy to respond. We can do that. Mm-hmm. Those cases are disposed of.
So I'm curious because I have a lot of copyright cases that go up on appeal, or idea submission cases, and they typically end up with a call from the mediator offering to participate in resolving them, and they never have resolved. So I'm just curious, how come those cases get picked?
It's up to the mediators or up to the judges to refer cases, and they will pick cases where they feel it is likely to result in the parties coming together because of the interests of the parties. But oftentimes we get a much better result than we could get. We had a case in Arizona, Hopi tribe, Navajo tribe. The Navajos surrounded the Hopis. A Hopi went to Berkeley Law School, came home, surveyed the land and said, Navajos are on our land. Here's a treaty of 1892. They won in the lower court. Navajos, Indians speak, you don't need the land. We've been living here since the early 1900s. But they went out and bought carloads of guns and said, we have the right to defend our land. Well, Dave Lombardi, our wonderful mediator who had worked on the Indian reservation in summers when he went to Chicago Law School, took 6 weeks. They sat in a circle. They waited till the spirit was right. They might sit another 2 or 3 hours. They ended up, the Hopi said the Navajos could stay. They exchanged $1. They signed a document acknowledging it was Hopi land. The guns are put away. They come to my court, I would have had to affirm the district court on the basis of that 1892 treaty. So what I say, to me, 85% or more of our civil cases could be resolved. Some cases have to go to trial. Brown versus Board of Education,
Yes.
a prime example. But it's faster, it's less expensive, it's less destructive, and we had an ADR meeting at this meeting just recently in our conference at the Hyatt, and I was just thrilled to see there were drug courts now that were working as alternative people who were incarcerated. At the end of that meeting, a district court judge said, you know, I'm looking at sentencing differently because I'm working with the U.S. attorney, I'm working with probation, I'm working with the public defender. I'm actually meeting these people who are coming back on these experimental programs. I don't look at number of years, I look at the person. And the success rate, even here, how many years ago? About 10 years ago, there were only about 6 of these experiments going on in the United States. Now there are over 68, a number of them in our own circuit. But to see judges and all the participants in our conference coming together and acknowledging they're not just cooperating, they're collaborating with each other, which I think is a huge step forward.
So, do you think that you're not having been a hardcore litigator for a long time and coming to the bench gives you a certain advantage on the bench that maybe some other judges don't have?
Well, when I was nominated for the bench,
Yeah, we have to hear about that story, how you got to be a judge.
Well, that has to do with my not being a hardcore litigator. Although I had litigated, I formed 2 corporations which still exist, and I hated it every time they called me up. They needed another lease, they needed another something else. I represented kids in juvenile court, many of them children of faculty members at the university. I did a variety of things, but Roscoe Pound again joined the American Judicial Society for me, for 10 of us when we graduated. That society was formed in 1914 to improve the selection of judges. I became chair of that society, and having been the only woman dean, every president appointed me to a commission of some kind. So
Sure.
I never belonged to a political party because Baha'is don't join anything that excludes people. So we vote and we're very active. So we wrote to Ford and to Carter and said, if elected, will you adopt merit selection for judges? Their staff wrote back and said, of course we will. So I was just floored 6 weeks after Griffin Bill was appointed Attorney General. He called me up and said, Dorothy, bring your group back to Washington. We're going to set up merit selection commissions for the appellate courts first. So I took a team back. 4 of us sat in, you're too young to remember, Attorney General Mitchell and his wife Martha.
Yes.
We sat in Martha's dining room. It had not been redecorated. Red flocked wallpaper, red velvet tulips, a red chandelier. It was like a bordello. But we
Sounds
sat
like it.
there for 4 days set up merit selection teams around the country. President Carter came in and said, I want these commissions to seek out women and minorities. Well, lo and behold, a few months later, they came by to see me. And I said, you know, I'm going to go home and think about it. I was finishing my 13th year as dean. I was ready to be just a plain old law professor again. I went home and my husband, a trial judge, said, you've been complaining about judges all your academic life. Why don't you see what it's really like? So I put my name in. 6 openings, 5 nominations were made in Southern California, 1 in Northern California. As I said, I didn't know Senator Cranston, I didn't know Senator Hayakawa. Senator Hayakawa was furious, went down, academic. He held up my blue slip. But our merit selection team said we didn't have to wait. And Senator Kennedy, whom I knew from another commission, called up and said, Dorothy, you've got the votes. Senator Hayakawa will not endorse you, but come back for your hearing. So just before my hearing, a messenger came and said, Senator Hayakawa wants to meet with you before the hearing. My heart pounding. I go into his office, but on the way, my mother, an English teacher, had used Senator Hayakawa's book on semantics for years. So I went in and said, Senator Hayakawa, I'm so happy to meet you. My mother has used your book on semantics in her classes for years. Oh, she has. Young lady, sit down and talk to me. So when I went in, he was a senior senator. He read my 3-page resume, line for line. Senator Cranston went like this, and that's how I got on the court.
Amazing story.
So you can never tell. I never sought it out, but I'm very, very glad that I did, because being interested in law reform and also being a Baha'i, with Baha'is have no clergy, but we have national assemblies in 182 countries. I'm often invited to other countries, and then I see the Baha'is as well. When I would go as a law professor, it was, oh, that's so interesting. Do come back. I go as a federal judge. How do we do it? When do we start? I find the impact that you can have as being a member of the federal judiciary, it's not deserved, because I'm the same person I was when I was a law professor, but it truly affects the attention that you get. And I've spent a lot of time in China and various places, India, around the world, and I find being a federal judge really enhances the exchanges with the others.
I'm sure that's true. And did you find it, coming from an administrative favoring mediation background, difficult to transition into actually making rulings and decisions when you first joined the bench?
I was scared to death, and my first hearing, say in Portland, Oregon, is a lovely little courtroom. It was raining outside, a fire in the fireplace. First judge comes in and sits back. Second judge comes in and sits back. I sit back at this big chair and go all the way to the floor. Bang. And that was my beginning of my law career. At that hearing, I was assigned 2 incredibly important environmental law cases. Well, you're used to legal research and so forth. But I wrote this opinion, and dear Judge Wright from Seattle called me up and said, Dorothy, dear, my, it's nice to have you on the court. This is really an excellent opinion, but I'm going to take it home and cut it in half this weekend. I said, Judge Wright, please let me do it myself. Well, I cut it in half, but having been an academic all those years, what did I get? Calls of professors from Pennsylvania, from NYU, from Columbia. You didn't cite to my law review article.
Oh.
And actually, in the first version, I had cited to all my friends because they had written magnificent things. And as Judge Wright taught me, we're writing for the clients, we're writing for the litigants. And I had, we all go through a learning process, but it was scary for me and also isolating. I was used to going to the faculty club with the deans of medicine and architecture and so forth, and there I was up at the 16th floor in the old building down there. When Judge Prager says, I complained. Judge Prager said, well, let's go to lunch once a month together. And there were about 7 of us: Judge Reinhardt, Judge Norris, Judge Ely. Then Judge Pegerson chose the City Hall cafeteria.
Naturally.
Which smelled of cabbage, and so we had one luncheon, and the other judges were never available again. Well, in our Pasadena courthouse, I have a brown bag lunch once a month during court week. All the clerks and all the judges come, and I supply coffee, tea, cookies, and punch. They bring their lunches, and I have one judge make a presentation. I have learned more about my fellow judges through these brown bag lunches, which are very well attended. And it's nice then when you go, nice thing about our circuit is I have chambers in San Francisco, Portland, Seattle, Anchorage, and Honolulu. You know the judges, you know their clerks, and email.
Do they hold those lunches in the other districts too?
Yeah. Oh yes, you get assigned by computer. And every year you pray and hope it's Honolulu or in Anchorage. About every 3 years we get
But you hold those brown bag lunches in those other districts?
No. But it's funny, when you get assigned outside my circuit, Pasadena, the first full week of every month is court week. So I always have the brown bag every month. When I'm assigned to someplace like San Francisco or Honolulu, it's always the second week. So I'm always home to have the brown bag lunches.
So other than that change, what do you see as the most significant change in the court in the years you've been on the court?
I think as we grow and the caseload grows, I mean, when I came in the court there were 23 judges, we now have 29. Everybody, wanted to split us up. Technology has put us in instant touch with each other. And next to my chambers across the hall, I have a conference room where I can see other judges at any time I want. That's good and that's bad. In the old days, I might dictate a note to another judge. My secretary would put it on my desk the next morning and I'd sign it. Now, you sit down and you punch the button, and there's a lot of traffic that goes back and forth that probably shouldn't be public. When I was thinking of right of privacy, yeesh, the thought of people in the public, because we know each other, we genuinely like each other. And one of the pluses of visiting other cities is you go to lunch and dinner with your clerks, with the judges, and that's when you learn about their families, and you become, it really is a wonderful court family. And my husband died last year, and I had been on the court, 30 years. Part of the spouses program. Jim loved the spouses. And Betty Fletcher's husband, and Mary Schroeder's husband, they were just bosom pals. And you know about each other's families. I come here and I feel I'm coming and seeing my family because we're all very close to each other. I think it improves our opinions. We have some very public discussions in the LA Times, the New York Times, and the rest, but we agree 90 to 95% of the time. And those are important issues to be discussed. Sometimes I wish they could be discussed more privately, but I think it leads us all to better decisions at the long run.
So is there any, the Navajo Hopi case sounds really interesting. Are there any other particularly memorable cases or particularly memorable judges or incidents on the court that really strike you as being something we should know about?
Well, one of my most fun cases when I came on the court dealt with districting in Northern California in a town, which I won't mention, that managed to district itself to exclude Hispanics. And that decision, striking that down, the lovely little letters I got in Spanish that came, it was very, very nice. My other memorable decision from my perspective dealt with an Eskimo tribe up in Alaska. When the pipeline went through little town of Veneti, was offered all sorts of money to give up all their rights. They were the only town that didn't take it. So when they began to tax people and so forth, district court says, you can't do that. Mm-hmm. And I said, why not? And so the case of Venety came out. I've been invited to give a talk in Australia. One of my good friends had brought the Aborigines together to meet and talk about their problems. When I walked in, they stood up and clapped. And on their table, they all had a copy of my Venety decision, which had not yet been overruled. It was overruled by the Supreme Court. It's talking about native rights. Mm-hmm. And that was a joyous experience. It was an unjoyous
result at the end.
But it gave me a rapport with them. And also the Maoris of New Zealand. With internet, it's just amazing. So those are two of the ones cases I do remember. And of course, I have the greatest affection for Judge Browning, because when at our courthouse, I was on the building committee, but restored hotel, next door bungalows, very wealthy, found the hotel too small. And Judge Browning called then Judge Kennedy and me to his office and said, we don't want neighbors who are incompatible. Judge Kennedy went off to become a justice. When I was dean at SC, I'd always wanted a research and development body in the West to improve the administration of justice. Everything is back east. You have the National Center for State Courts, you have the Federal Judicial Center, you have all of these centers. So, thus was born the Western Justice Center, which is right next to our court. And you don't have time to hear the ups and downs, but Judge Browning agreed to come on the board of the Western Justice Center. And I've always had at least 5 appellate judges, which has made a big difference in how we're viewed and respected. One of my judge now deceased, a former congressman, said, you shouldn't mess around with that kind of stuff, Dorothy, because the government wanted to sell the land. And I got a congressman to separate out 4 of the 13 bungalows that were there. And through some opposition, back and forth, we acquired those buildings, and it's a going center to promote the peaceful resolution of conflict among children in the courts and the community. And that has been something that's brought a great deal of joy to me.
It's a great legacy.
Well, no, it's hopeful that the judges who opposed it at the beginning, I think have now passed on, but were widely respected. And just one small example, in the city of Pasadena 2 years ago, 4 years ago, 2 years more recently, a police shooting of a black man. The police chief attempted at the Jackie Robinson Center to meet with the community, and they booed him out of the room. And Chief Malekian came to see me and said, Western Justice Center is nonpartisan, non-political, respected in the community. Will you help us conduct a dialogue with the community? We did. He's allocated money to us to train his police officers and how to deal especially with teenagers on the streets, instead of slapping on the handcuffs when it's not a violent crime. Mm-hmm. So you have a feeling we're in a nice community there, we're able to experiment, and that's what a lot of pleasure.
That's great. So you've been interviewed so many times. What have people not asked you about that we should ask you about?
Oh dear. You've been a wonderful interviewer, really. It must get pretty tedious because there are just so many different kinds of things. Really?
Yes.
Harder. But thank you so much. It's been a great pleasure.
Well, it has been an honor for me to get to interview you.
Well, Gail, I hope you'll come visit my court. We always have coffee, tea, punch, and Girl Scout cookies. As my judicial assistant is a Girl Scout leader, I help her daughter win the prize every year by buying 80 boxes of Girl Scout cookies. I'd love to have you come by.
I'd love to come by. Thank you very much.